Should you copyright your business name or should you trademark your business name? Well, that's a good question, and we're going to talk about it in this video. I'm L.A. Perkins, a brand protection attorney. I help business owners and entrepreneurs identify and protect their intellectual property assets and enforce those rights so they can avoid costly mistakes and increase the value of their businesses in the long term. So if you have a business and you want to make sure that your brand assets and intellectual property are protected, feel free to check out some of my other videos on my YouTube channel, as well as the information on my website. And if you want more information, reach out and schedule a consultation with me. One of the common questions I get from business owners is, do I need to protect my business name with a copyright or a trademark, and what's the difference? In this video, I'm going to share with you information about copyright protection and what that provides, as well as information on trademark protection and what that will provide, so you can consider your options. So I get, as a business owner, you're running around doing a million things, and this is probably not on the top of your list to deal with. However, it's very important that you address these issues and protect your brand sooner versus later, so that other businesses, often competitors, can't mess with your business. The reason why you want to do this as soon as possible is so nobody else can use your company name in the United States. So when it comes to a trademark, anything that you use that identifies and is unique to your business could be deemed a trademark. It's a source identifier for your particular goods or services. So for example, a trademark that everyone's familiar with is the Nike swoosh. That's a logo design trademark. On the other hand, a copyright is basically a creative work that is fixed in a tangible medium. So we're talking about brand protection here, and how copyright protection applies to brand protection is oftentimes people create a very unusual, particular logo for their business, and they can protect that logo through filing a trademark application, but they can also protect that logo by filing a copyright application. The trademark application protects it as the source identifier for its business. So in other words, if somebody took that logo and was competing with them, possibly diverting business away from them, using that logo, they can stop them. With a copyright registration, it doesn't have to be the same business that's using it. It could be any business that is using that design. You could stop them. And there's different damages that apply to copyright registration as well as trademark registration. And by damages, I mean, once you have those registrations, in addition to be able to get actual damages from an infringer, you can also get what's called statutory damages. And that means a fixed sum can be awarded. In the instance of copyright infringement, that could be anywhere from $750 to $30,000 for an infringement. And if it's willful infringement, it goes up to $150,000. And the other benefit of having registrations, that's copyright registration as well as a trademark registration, is it gives you the right to claim attorney's fees if you're successful in your infringement claim. So as you can see, there's lots of things to consider. But if you've got a big vision for your business and you want to ensure your success, it's really necessary for you to protect your brand assets to the fullest extent possible. If you have a creative logo that's unique to your business, you should consider filing both a trademark application for that logo as well as a copyright application for that logo. The reason I recommend this is because it will give you the broadest protection possible. But I do want to let you know something which comes up often in my practice. When you have a contractor work on a logo design for your business, it's very important that you have in writing that you own all the rights to that logo. So here's what I recommend you do. Get a sheet of paper and write down all of the brands, the specific names that you are using in your company to identify uniquely your products or your services, and all the creative works that you have, all the logos in your company that you are using to identify your products or your services. And put those all on a list and reach out to a lawyer to talk about what's going to be the best way for you to protect those brand assets. The reason you want to protect your brand assets is so that you are in the best position possible to stop another company from infringing on your rights. Without having those registrations, you are not in the same strong position. I've had clients that were on the fence maybe initially of whether they wanted to invest in protecting their brand assets. But once they found out that another company was using their same brand name, they were so happy that they did. And it would have been penny wise and pound foolish for them not to do so. So if you have a business and a website and you're doing business online, you have intellectual property that needs to be protected. Don't delay. Doing so could really cause issues for your business that you can avoid by being proactive. Call my office today to schedule a consultation and get your brand armor on. If you're looking for more information, check out some of my other videos on my YouTube channel and like, subscribe, and share, as well as additional information that's on my firm website.